A very warm welcome to everybody who's joining us. We're just going to give it a few more seconds before we kick off. You're in the right place if certainly you've signed up to a webinar looking at intellectual property protection of digital innovations. So you found the right webinar. So we're just going to give it a few more seconds to allow. We've got a good number of people joining today. Clearly a very interesting, as we thought it would be, a very interesting topic. So we're just going to let a few more join, and then we will get started. Right, why don't we get started then? Thank you again for joining. Quick introduction from me. My name's Martin Hayward. I'm the head of digital and data at Altamimi. I'm joined today by Ahmed Salah, who's a partner and head of our patents and designs practice. And Ahmed will introduce himself and his practice in a little bit, but my job very much is to introduce this session, and I'm delighted to do it because it's a really certainly it's a current one. It's an important one. It's one we work a lot. It's a topic on which we work a lot with our clients. Very quick introduction of Altamimi if you're new to the law firm. So Altamimi is the largest independent Middle East and North African law firm. Little slide here about us. We've got a lot of people in a lot of different places. And what that means really is that we're doing some really interesting work for some really great clients across the region, particularly in the digital space. And that's what makes this session so important. And I'm glad you've joined us for it. We can just flick on to the next slide, just to kind of show you where we are in to say a lot of what we've been doing is in the digital space is really regional in nature, as we've seen the build out of regional digital footprints. So why is it important we're talking about this today? Well, really what we've spent the last couple of years doing, and this was pre-COVID and it accelerated through COVID, was digital transformation projects for our clients. You're probably sick of hearing the term digital transformation now, but it's been a really important move from our clients online. And one of the key focuses that we've worked with our clients is building that digital IP strategy, because of the speed of change we've seen over the last couple of years. And I'm a technology lawyer, and I've been working in technology law for the last 15 years. And we've not seen anything like the kind of change we've seen. We've seen bricks and mortar businesses move completely online, completely transform their businesses at an incredible pace, driven by necessity during COVID, and just the fact that from competition and disruption in the market and new entrants, there was a requirement, there was an imperative to get online, building whole new infrastructures, bringing in new features and new functionality. And what that really focused on was the need for a detailed digital IP strategy. And IP management in the digital age is a really important element. And one thing we really saw was clients, not just simply at the startup end of the ecosystem, but fully across the ecosystem. We saw clients moving so quickly to get online, whether that was to capture competitive advantage, whether that was to beat the competition, whether that was just to survive during COVID. Really, it was what we've seen is the real focus on the technology, on the business, often sometimes not on the IP. And that's why this session's really important, because the value of those businesses, so much of that is in the IP and the intellectual property. And it's not simply about the protection of it, but it's also building it to be able to exploit it, to be able to monetize and commercialize it. And what we saw were clients bringing together different products, licensing them, building their own, pulling in lots of different technology, lots of different IP, putting it together. It's created a really complex IP mix within our clients. And it's really important to pick that apart and look at what's important within that IP portfolio, what needs protection, and then the key point, and this is what we're really going to focus on in this session: how do you protect it, and how do you protect it effectively across the region? So to tell us about that, I'm going to hand over to Ahmed Salah. Ahmed will introduce himself. Just a quick we're going to talk for about probably 45 to 50 minutes. We want to leave time for questions. It's important that you get an opportunity to reflect on what we talk about and then ask those questions. You can put those in the Q&A or in the chat boxes. You can see those at the bottom of your screen. What we will also do is, look, if we don't get to your question during the session, and you've probably been on lots of webinars and there's always lots of questions, and we welcome them, we'll certainly be following up with you afterwards. So please, be reassured that if you don't get your question answered on the session, we'll make sure that we're following up with you. So at that point, I'm going to hand over to Ahmed and ask him to present the session.
Thank you very much, Martin, for the introduction. Good morning, everyone. It's my pleasure to be here today. So by way of introduction, I'm Ahmed Saleh. I'm partner and head of patents and designs, R&D and innovation at Al-Tamimi and Company. By way of background, I'm a computer engineer by background, computer and electrical engineer. So and I'm a lawyer, and actually a big part of my team come with two backgrounds, legal and technical, to be able to work in the technology and innovation space. So what we basically do, we work a lot with our clients, and our clients can range from universities to research centers to private and public enterprises to entrepreneurs and startups. So we help them basically in protecting their innovations, commercializing these, and enforcing their intellectual property rights in general. This topic is a very important topic. Why? Because of all the changes happening today and all the transformation taking place. And intellectual property is something which cannot be overlooked. It's a key legal right, which provides a lot of value to enterprises which focus on innovation. So innovation-based companies and enterprises would find a big chunk of their value, of their monetary value in intellectual property. And this is today what distinguish companies from others, and it's going to be more obvious in the upcoming years is how much intellectual property in terms of value do these companies represent. For sure, for established companies, it's a sword which will help them to keep the competition out, to keep their competitive edge. And for new entrants, it is kind of a weapon to be able to gain a chair on the negotiation chair if ever they want to negotiate, for example, certain joint ventures with established companies, or they simply want to come into the market and establish their presence. It's a kind of monopoly which will help them to be able to make a breakthrough in the market. So if we look at digital innovation, of course, is a big term. When we speak about digital innovation, basically we want to see two things, which is a software and a hardware. So normally there's a software running on a computer device, and this computer device can be a computer system, or can be a gadget, for example, or can be an iPhone, for example, if we speak about mobile applications. So mobile applications, digital gadgets, devices, and medical devices, for example, which use basically software, AI, and blockchain-based applications and devices, are all different types of digital innovations. And they share something in common, which is that you can find a software which is running on a microprocessor or a computing device to establish or to deliver a certain function to the user. When we speak about IP protection comes in different forms. There are various vehicles which are established by law to protect creativity and innovation. And I've cited here 4 main intellectual property vehicles which find application in digital innovation. So patents is, of course, the first legal vehicle which applies to digital innovations, and the patents are there to protect inventions, are there to protect technical solutions to technical problems. So a patent is there to protect the innovative concept and a technology underlying the technology. And can really secure a very wide scope of protection because it concerns the concept in itself, to protect the concept, the technical concept in itself, so it can secure a wide scope of protection if it is successfully obtained. From another side, looking at more the interface or the layout of the innovation in itself, or the ornamental or visual features of that, you have industrial designs. Industrial designs are another legal vehicle, intellectual property vehicle, which are there to protect all the visual features of an innovation. So you can think about a user interface, for example, whether a user interface is on a physical product, such as a gadget, for example, or a watch, such as, for example, the Apple Watch, or it is on a digital screen, for example, such as a mobile application, for example. The trade secrets is a third important intellectual property right, and is there to protect confidentiality or confidential information. And in digital innovation, there is a very important part normally embedded in the digital innovation, which might be subject to trade secret protection, or would be interesting or beneficial for that information to remain confidential and not to be disclosed to the public. Where patents normally require publication while drafting and submitting a patent application to the patent office for examination, we need to disclose the technical information. It's very important to define exactly what should be included in a patent, which would be subject to disclosure, and what should remain confidential as information. And we can think about specific algorithms, for example, or mathematical formulas, for example, which is beneficial to remain confidential. You can think of, for example, about the Google searching algorithms, which a lot of them remain confidential and have not been disclosed. And the key here is really this information not being easily accessible, or can be reverse engineered by others. Because as long as this information remains confidential, it keeps confidentiality and it keeps protected. However, if a third party is successful in reverse engineering this code, then you would lose protection. The fourth form of IP which applies to digital innovation is copyright. And copyright there is about protecting work of authorship. For example, in applying it to digital innovation to software, it's there to protect the source code in itself, for example, the expression of the source code in itself, the database structure, for example, and it finds a big application in gaming. Let's speak a little bit about patents. Patents, as I mentioned, are very important for digital innovations. Why? Because they can secure a protection of the innovative concept in itself. And we will speak a little bit later about this innovative concept and what it can imply in digital innovations. However, patents are more difficult to obtain than the other forms of intellectual property, because the threshold for providing, for granting patents is higher. And once a patent is granted, it will provide 20 years of monopoly to the patent owner. So the patent owner will be able to exclude others, all competitors, from practicing the invention for a 20 years period. We're going to talk about these patentability conditions a little bit later. So for a patent, examination is required by a patent office. A patent office is part of the government bodies, and normally under a ministry. In the United Arab Emirates, for example, is under the Ministry of Economy. So they receive these patent applications, they examine it, they search it whether it complies with the patentability conditions, and after goes and forth with the patent attorneys, then they decide whether to grant a patent or to refuse a patent. In most cases, we are able to successfully obtain patents for our clients after amendments or legal and technical argumentation with the patent office. So once a patent is accepted and granted, a patent registration certificate is issued, and you can use it to enforce your patent rights against any competitor or third party using or exploiting in any manner, selling, offering for sale, importing, or manufacturing this invention without your authorization. And also with patent rights, as Martin mentioned earlier, it's a great way to commercialize your IP. Without an IP right, there is little to commercialize. So a patent, once obtained, gives a big boost to your value, to your company, from the value perspective, from the monetary perspective, and from the competitive edge perspective. Patents, however, are territorial. If you want to obtain protection in a specific country, you need to file in that specific country and obtain a patent in that specific country. For example, in the UAE, a patent application should be filed to the UAE Patent Office and being granted a patent for you to be able to enforce your patent rights in the UAE. So what are these patentability conditions? The invention needs first to be novel, and novelty is absolute, so it's worldwide. If something is already existing in one country, for example, in the United States, and never been used in the UAE, it's still something which is not novel because it's already existing. You cannot come and claim patent rights for that specific technology in the UAE only because it has not been used in the UAE before. So novelty is a worldwide and absolute requirement to be met. Non-obviousness is another criteria which is very important for digital innovations, and normally it is a very subjective, objective test. So the question whether the inventive contribution of the technology is not obvious for a person skilled in the art, meaning a technical person in the art. And this is a question which is asked by the patent office, whether reaching to the invention takes something more than being trivial, is something which is inventive, is not obvious. And this is a test which vary from one jurisdiction, one country to another. Each country might have their own standards and tests on how to apply and how to assess inventiveness and non-obviousness. Utility is an important criteria, and while utility condition is normally met for physical products because they do have a useful application or industrial application, a physical practical application, for digital technologies, which are more software than hardware, more on the digital space, utility is normally finds more application or more raised by patent offices to ask the question whether that digital technology is useful, meaning has a practical application, meaning it's transforming something physical or having some kind of industrial application or practical application. And again, the tests for utility, particularly in the digital space, are sophisticated and vary from one country to another. The US might have their own standards, and Europe has their own standards with respect to utility. So while drafting patent applications, of course, for protection globally, we pay a lot of attention on how to draft the patent application in a manner in order to enhance its chances of being successful in front of the major patent offices where the client would like to protect the invention, such as Europe, the US, South Korea, and other countries. An invention needs also to comply with an eligibility test to be able to obtain a patent. So there is eligible subject matter for public policy reasons are there in the law. And if an invention, even if it's novel, even if it's inventive, and even if it's useful, doesn't comply with these kind of eligibility category, cannot be granted a patent for public policy reasons. And we're going to see a couple of these which apply to digital innovations. And finally, an invention needs to comply, specifically speaking about the region here and the United Arab Emirates, need to comply with public, moral, and Sharia in order to be granted a patent. So if a patent application is deemed not to comply with our public, moral, and Sharia principles in the United Arab Emirates, it can be rejected by the patent office. So speaking about what is the eligible patentable subject matter, we've cited here a couple of examples of eligible patentable subject matters which apply to digital innovations. So a product, a device, a system, or a data process are all eligible subject matter. So if we claim our invention to be a system or a device, it's a physical product. A data process, which is can, for example, be part of a computer implemented process or method of processing the data in order to achieve certain functionalities. This is patentable subject matter because specifically speaking about the data process, it is connected or being implemented using the hardware or the processing unit. Now, non-patentable subject matter are some examples are mentioned here. Speaking about a computer program, meaning the source code in itself, the CD, if you take that medium in itself is not patentable subject matter. You cannot take a medium with a source code and say, I want to obtain a patent for that. However, the underlying process and functionalities and the innovative concept underlying that software can be patentable. And this is, I'm going to speak a little bit more about this in the upcoming slides. So there's a very clear distinction to be made. A computer program is something which is protected under copyright. So if someone if, for example, a company comes up with a software and puts it on a computer medium, and then this is being copied and dispatched by some companies or by third parties, this is a clear copyright infringement. However, if someone takes the underlying concept of being implemented by that software, the underlying concept, the innovative concept, and reproduces and goes independently develop a source code for that, there is no copyright infringement. And this is where the copyright falls short of protecting the innovative concept. And this is where the value of a patent comes in place when it comes to protect that innovative concept in itself. And we know by fact, for all technical people and engineers know very well when we look at a technology or an application, for example, a mobile application, it's not necessary to go and copy the code. So if one understands what is the innovative concept behind it, and decides to do a similar innovative or a similar application with a similar innovative concept and develops it independently without copying the source code, this is designing around copyright protection of that mobile application. If there is no patent protection for that concept, unfortunately, there is little to be done. So business models, pure business models, are not patentable subject matter. For example, Uber, for example, cannot patent the concept or the model, the business model in itself. For example, of having decentralized, for example, vehicles transporting people. Yes, there are a lot of patents in application to the Uber technology, which we're going to see a little bit later as examples, but as business model in itself, you cannot come and protect a business model in itself.
Ahmed, I'm just going to, sorry to jump in there very quickly. I just want to double check. Amar, thank you very much for flagging this on the Q&A. I just want to make sure the slides are moving on. I know you've got a lot of slides on this topic. I think at the moment I'm seeing slide number 6. So I just wanted to make sure that we were moving the slides on. Not an issue, because of course we'll be sending these slides out afterwards, but I just wanted to double check.
Oh, I have here slide number 10, Martin.
Okay. Right. Let me. Apologies for interrupting. Let me keep you going. We can certainly, as I say, move this. People are just saying that the slides aren't moving, but let's keep going, and we'll see if we can fix that in the background. But we'll certainly send the slides out to everybody afterwards. So they're very colourful, but you're not missing an enormous amount from the slides. As I say, it's very much what Ahmed's saying that's the key. So Ahmed, apologies for jumping in. Please keep going.
Sure. So the slides are moving, right? Yeah.
Not at the moment, no. Not on my screen.
Okay.
Maybe if we refresh them and come back in again, then we can, maybe if you
Okay, let me stop sharing and then share again.
As I say, if people have got any questions, just a quick reminder while Ahmed's just kind of refreshing the slides, do please drop them in the Q&A and or in the chat. And right, I can see number 11 now. Hopefully everybody else can. Yeah, that's moving perfectly. Great stuff. Thank you, sir.
Thank you, Martin. So this is the slide we're speaking about patentable subject matter and non-patentable subject matter. So as I mentioned, business models, pure business models, are non-patentable subject matter. For example, if you take the example of Kitopi, a cloud kitchen business model in itself, this cannot be patented or protected as a business model, neither under patents or any other IP right. However, there might be certain trade secrets in application, for example, to make that model successful, which is applied inside the kitchen, for example, how to process food, how to process, how to deal to expedite the process, for example. So these kind of details, which are technical or business in nature, can be subject to trade secret protection. For example, if there's a specific application to make this business model successful in terms of implementation of that mobile application, for example, that's something that we can look into the patentability of, but as a business model in itself, it's not something which can be protected. A financial model follows the same principle, a mathematical model follows the same principle, and in general, these are considered abstract ideas with no connection to technicalities and cannot be protected as a public policy for public policy reasons. And normally the reason behind it is that the government doesn't like monopolizing businesses in general and like to keep the market open for competition. However, patents come as an exception in application to specific technical solutions, specific implementation of certain technologies, which can be protected. So all of these models we see here, financial model, mathematical model, business model, they can be part of some specific technologies or applications. For example, we normally find in AI-based devices, for example, or technologies, mathematical model as part of the computer algorithms, or financial model as part of the computer algorithms. And that's totally fine. These normally we keep them as trade secrets. And however, we focus the protection under a patent on the concept in itself. And that concept being concretized or being delivered by running this software code, including the algorithm. So the algorithm is there to help in delivering a certain function, a specific function, and a technical contribution, a technical solution. In this way, it is protected as part of the entire concept. So when we speak about the patentability of software-related innovation, we are normally looking for a technical character or a technical contribution, and not a pure abstract idea or a pure mathematical model. So we cannot take a mathematical model and protect it through a patent. However, that model is normally part of the computer algorithm and makes the concept or the delivery of the concept possible, makes the delivery of specific functions and applications possible. So when we go and protect through a patent, we are protecting the process underlying the software. If you take it as a flow chart, for example, what is specific software achieving in terms of results? So what is it taking as input, how it's being processed by the microprocessor, and how it's being dealt by the microprocessor, and what is the outcome. So this is what we focus on as patent protection, rather than the specific, details of the source code or the specific details of the mathematic model. Of course, if you take that mathematic model out of the processing unit, you will not be able to achieve the outcome you are achieving. And this is how, in this way, the mathematical model is important for the patentability of a software-related innovation, and makes it possible. And the same apply, for example, for a financial model when it's part of that algorithm as well. So we are focusing for software-related innovations on computer-implemented methods. So it's a computer-implemented method. It's a method of processing data using a computing device. And this method would comprise certain steps or certain actions of what kind of information or data we are inputting or we're obtaining, and how we're obtaining it, how this data is being processed by the microprocessor using specific algorithm, which can be based on artificial intelligence, for example. Okay, and what is the outcome or the output of that black box, if you want to consider it, and how this output changes the world around it. So this is what we focus on when we go into the patentability of software-related innovations. And we normally look at things from different perspectives. We look at it from the machine perspective. So what is the machine doing to this data, and how it's changing this data, and generating the outcome, and how this outcome is changing the world around it. So this is from the machine perspective. We are protecting the process. And also we look at it normally from the user perspective. So from the user perspective, what is the user doing as well, using a machine or a device or an iPhone, for example, and what is the process being followed, and what are the features being delivered to that user. And we try to capture a holistic picture of that concept, taken from both the machine perspective process and the user perspective as well, and try to get the widest scope of protection possible from both perspectives. So when we look into digital innovation, there are normally three different categories of innovations which we look into the patentability of. So the first category is fundamental platforms and methods technologies. And this is normally related to fundamental principles or fundamental platforms like machine learning, neural networks, for example, the blockchain linked lists. So these are the foundations or the first layer of technology, which is normally used as a base to develop applications over it. And normally, as you would guess, these kind of technologies are normally pioneering technologies, and they are few. There aren't a lot of these. If you look into blockchain, for example, yes, there are a couple of maybe dozens of patents around these fundamental platforms around the blockchain technology, such as the linked list, for example, and how the sequencing is being done, how the listing is being done through the different chains in that blockchain platform. And these kind of fundamental technologies are being protected. For AI as well, the neural networks and machine learning, when they were invented or firstly invented, there are patent protection for these as well. So these are the fundamental platforms and methods which are normally used by developers and later on by users to develop their own inventions and their own applications. So the second layer comes as functional, we name it as functional technologies. And these functional technologies use these fundamental platforms and methods. So when today, for example, you develop a blockchain or AI-based application, for example, to deliver certain functions, you are not recreating the blockchain platform from scratch or the neural network from scratch or the machine learning principles from scratch. You're using these platforms. So functional technologies are of course, in terms of volume and number, they are much more present than fundamental platforms. So this is what today most of the developers and innovators, they focus on to develop certain functions, certain functional technologies using these platforms. And of course, the emergence of these platforms as a blockchain or AI, for example, is enabling and making possible the emergence of a whole new world of new innovations, and which focus on functional technologies and application technologies. For example, using blockchain to conduct a real estate transaction, for example, without involving, for example, notary public, for example, as physical presence for the certification of the transaction, for example, or without involving the conventional way of involving agents, for example, or brokers, for example, or so you can see this is a specific technology which is made possible because of the presence of blockchain. It uses the blockchain in order to deliver something which is completely new and is solving a problem in the industry. So that kind of technology can be protected and is a functional technology. In some cases, for example, you find a new innovation coming out which focuses on a specific application. For example, Uber is already existing for vehicles. You're using the Uber kind of concept in order to implement it in connection, for example, to whatever healthcare professionals or to plumbers around you in order to, for example, locate the closest plumber around your house, for example, whatever. Okay, so this is a specific application. Yes, these may be patentable. However, of course, there are conditions to be met. The new applications need to also be inventive and not be trivial. It's not like, it shouldn't take something which is existing, for example, and only changing the terms or the generic terms. For example, instead of a car, you replace it by a bicycle, and you're doing exactly the same thing, and you're saying this is a new invention. No. If using a bicycle instead of a car requires you of implementing things differently as a question of technicalities and how the data is being processed by the computing device, how the distance is being, for example, measured, because there's more challenging to, for example, determine the location of a bicycle in terms of resolution than a vehicle, for example, especially because of also the bicycle doesn't move at the same speed as a vehicle. So there are some challenges which are out there, and you solve them using the new application, then these can be patentable. So what is the approach for the patentability of these? So it's important to remember that the patentability test varies from one country to another. The US has a sophisticated test for the patentability of software-related innovations, or what we name in the legal industry computer implemented inventions. Europe has another test, China has a test, South Korea has a test, and basically every developed jurisdiction have their own test how to assess and define these. In general, you need to have a technical solution to a technical problem. What is technical, what is abstract? This is subject to the different tests, which vary from one country to another. But when we draft a patent application for a technology, for example, it's all of these, we take them into consideration in order to make the patent application as immune as possible to the fluctuation of these different tests throughout the main big jurisdictions. And we always try to focus on the inventive contribution being in relation to the technical elements. And normally a technology, as you know, can comprise technical elements and non-technical elements. So for example, it can involve some kind of specific manners of processing the data, for example, as being technical in nature. However, can also involve, for example, doing certain non-technical stuff, for example, which are being done by a human. It's important that the inventive contribution or the novelty that being applied to those elements which are technical in nature. I'm going to speak very quickly about copyright. As we mentioned, copyright is applied to normally work of author. The expression of these for digital innovations, you would find it normally for softwares or the source code in itself. So if someone takes your source code or substantial part of that, copy that, this is copyright infringement. If someone takes your concept behind your software, okay, this is not copyright infringement. So the scope of protection of copyright in relation to that is quite limited, and you should always look beyond copyright protection if you have a new innovation, a new innovative concept, and the process behind your technology. Normally, for the copyright protection, the term is 50 years after that, and there is normally no registration is required, unless in some countries where you need to enforce your rights, such as the UAE, for example, then it's highly recommended to register it. But you need to be very, very careful with registration. Why? Because registering copyright, it's delivering in some countries like the United Arab Emirates, you need to deliver the source code to the Copyright Office, and this may be considered as a disclosure of the source code to the public, and then this would compromise the patentability of any invention underlying that. Why? Because as you remember, we spoke about one of the main conditions to obtain a patent is novelty. the invention needs to be novel, completely novel, absolutely novel worldwide before you file your patent application to the patent office. So if you file for copyright registration, you take your source code, you disclose it to the Copyright Office, and it's assumed to be in the public domain, then this may constitute a novelty destroying to your invention. So you shouldn't be doing that if you believe there is an innovation concept you want to protect under a patent. And if copyright registration is required, we normally do it after patent protection, after we file a patent application and not before. Trade secrets, we've discussed it very briefly. It relates to technical and business information and know-how. It's very, very important in digital innovations, very important. It relates most of the time to these algorithms, to the specific, formulas in the algorithms that makes the delivery of these function and of the outcome possible. We've mentioned as example the Google searching algorithms, for example. In the physical world, physical products, normally in mechanical related inventions, for example, trade secrets are less applicable. Why? Because you can basically reverse engineer any mechanical product. If you look at it, and then you open the black box and you can reverse engineer it and reconstitute it. So trade secret protection would be they're compromised. But in digital innovations, with the software and that algorithm and the specific formulas, AI related or not, in this algorithm, it's very difficult to reverse engineer it. And try to reverse engineer the Google algorithm, for example. So they can be very important, and it's very important to keep it confidential, and you take measures to keep it confidential, and it's a requirement in the law. So trade secret protection is secured as long as the information remains confidential. It represents a value for you and for your company, and you take all the measures, reasonable measures to keep it confidential within your organization. You make your employees sign NDAs. You don't disclose it to investors, or you don't disclose it to developers without signing confidentiality agreements. So you need to take the measures to keep it as confidential as keep it completely confidential, actually, vis-a-vis the public. There's no legislation required for trade secrets, and trade secrets need to be taken into consideration very seriously while protecting an innovation. I'm going to discuss quickly this subject, machines as inventors. Just to mention quickly, it's a developing area. So far, the positions of major jurisdictions is against the machines being considered as inventors. Why? Because according to the dominant school, only humans can be inventors, and machines cannot be inventors. And there's always a human behind a machine. Even if the machine made it possible or helped in achieving something, there's always a human mind behind that, which made the invention possible, and that person should be named as inventor. And there are some case laws which came from the US and the UK rejecting machines being named as inventor. In South Africa, the patent office wanted to maybe get a scoop around that, and they accepted a patent while the inventor was named a booth is a machine. However, the court came very quickly to revoke that a couple of days later. Some examples, and these are nice examples. I'm going to go quickly through them in 5 minutes. So this is kind of digital innovation. You would have hardware, you would have software. This is an example of a Fitbit watch. And as you can see here, you have the screen, for example, which is subject to protection. You have the bracelet, which is subject to protection as shapes or as visual features. And these are normally go under industrial design. And you have some hardware sensors and which are normally protected through patents. And you have certain codes inside there, which as a source code in itself is copyright protected and it's automatic. You don't need to register. And there are certain information inside there on how to process the data, for example, specific mathematical formulas, for example, which would remain a trade secret, even if you obtain a patent on the concept, as we will see. Here in this, the Fitbit example, there are over 1,000 patents published in relation to that technology. And from the utility patents perspective, it's around the sensors, the accelerometers, the ways and the processes for detecting and measuring, information around health, and determining the activity level via movement. So there are a lot of patents around that. And from the design perspective, for protecting the visual features, there are designs, industrial designs, or design patents, the way we name it in the United States, around wristbands, around the cable, around the feel or the shape of the screen in itself. And of course, trade secrets are part of that. There are certain information, certain algorithms, mathematic formulas, which remain as trade secret. Even if you go through all these patents and designs and try to do the same and reproduce, you will still be missing something. And that thing is kept confidential and secret. And this is the art of protecting a digital technology. We need to think holistically, the full picture, the combination of all the 4 rights I've just mentioned in a strategic and well-balanced manner. And this is the best protection you can get. Uber is another example. Here, there are more than 5,000 patents around the Uber concept, and patents around the processing of the data, how you process the data, so data processing systems and methods in order to achieve the functionalities of the Uber application, the measuring of distances, the levels or bearings, how you, and there are a lot of inventions around systems for controlling, regulating non-electric variables. These are generic engineering terms, as you see, and why we do that normally as patent attorneys is to make the flavor as technical as possible in order to pass the test and make it also wider in scope. So these terms you see here, right, it would apply to it as scope, it would be wide and can apply to maybe Uber kind of application and other applications. So we try to widen the scope of protection and make the flavor more technical to increase the chances of the application being accepted by the patent office. It's part of the, the way we draft patent applications. For design patents, you'll see there are patents around display screen, for example, and the user interface. This is another example, PayPal. Again, you'll find a lot of utility patents and industrial designs. The designs are around display screens, user interfaces normally, and the utility patents around all the different other technical aspects underlying this PayPal concept or application in terms of processing the data, in terms of delivering the functionalities to the user. There are a lot of technicalities around that, underlying that, which we protect through a patent. And this is what provides protection to the company. In addition, of course, to trace some certain things are kept as secrets and are kept undisclosed, which also add to the protection. This is another example for Spotify. And again, the same principle applies as the previous ones. There are more than 700 patent publications for that as well. And patents around speech analysis, for example, and transmission of information. A lot of these as well. This is an example, and I put this just, because I know that most of you would know the Smart Palm, on Kite Beach, and it's something that we've protected, our team worked on. And here it's a nice example where we've applied, industrial design protection to protect the leaves and, the visual features in itself. A lot of utility patents on, how to generate the energy being used as autonomous energy being used, from different sources, solar system, kinetic energy, from people walking on kind of rubber carpet, which captures, the vibrations and the kinetic energy and transform it into electrical energy. And there are certain things which are kept as state secret, of course, as part of that. So what are the key takeaways from this presentation? Digital innovations are extremely rich in IP, and they can be subject to different types of intellectual property, which should be balanced up and used strategically to have a holistic protection of the digital innovation, and in a very strategic way. And timing and the order of these protections is very important. You cannot file for copyright registration without first considering patents and industrial designs, because that, if you do that, you would compromise irrevocably the patentability of your inventions, or the possibility of obtaining patent and industrial design protection. So, you need to take this to be dealt in a very strategic way and in a very holistic way. So that's the presentation. I think we still have a couple of minutes for questions and answers. Hopefully, Martin.
We do. We've got some questions coming. Ahmed, many thanks for that. We've got, actually, I think probably this one was the point you captured right at the end. We got a great question that came in just saying, is it recommended for a company to use all 4 vehicles to protect its IP? If not, what would be the preferable vehicle to seek? And are there any cost considerations to be aware of?
Sure, absolutely. It all depends on the nature of the innovation. And if the digital innovation would imply, and normally the first step, Martin, is really to look into the components of the digital innovation. And this is really a technical mining exercise. So what we normally do, we sit with the client and we dive in the technical details to determine the different technical components. And based on that, on the nature of these different components, then we determine what are the legal vehicles, the IP vehicles, which should be used to protect these. So there are certain parts we would go with a patent for that, certain other parts, industrial designs, certain parts we would recommend to keep as a trade secret. So this is normally how we deal with things. Yes, a holistic view of this is very important. Using the 4 vehicles to protect a digital innovation is, of course, the most strategic and the most preferable way of doing things. However, how things should be done, how it should be dealt with in a strategic way. So looking holistically at the nature of the invention, understanding the technicalities, and defining a protection strategy for this before execution.
That's a great answer. I think we've just literally got about 30 seconds for a very quick answer. We've got a second question from Ammar. Ammar, many thanks for the question. What about protecting the business name? Where does it fall under? Brand identity, logo? Give us a very quick, Ahmed, kind of 15 seconds on that.
For the business name, this is normally falls under a trademark protection. It's a straightforward exercise. So for example, the name PayPal, for example, or the name Uber, this is subject to trademark protection. It's through filing a trademark, applying for trademark registration for that name or that logo. It's a simple, straightforward exercise.
Perfect. Great answer. We've come to the top of the hour. We appreciate everybody's time. We know you've got busy days, so thank you for spending an hour with us to kind of work through this topic. Emails are on the screen, contact details are on the screen. Do please reach out to Ahmed, to myself, if you've got any further questions. Lots to think about, lots to reflect on. We really look forward to receiving your reflections. Any follow-up you'd like, look forward to hearing from you. Just leaves it to me very much to thank Ahmed for a fantastic presentation. Really appreciate the opportunity to deep dive into that. Really captures the things you need to be thinking about, going back to what we started with about building that digital IP strategy. So thanks again, Ahmed. Thanks to all who joined. Look forward to having you again on future Al-Tamimi webinars, but I wish you a very good day, and we'll close the session here. Thanks so much.
Thank you, Martin. Thank you, everyone.